In the transfer petition, Honorable Supreme Court called both parties, made efforts, and
Is it the case where the cost for traveling?
exactly same. Actually,
They have already paid me.
So your petition also has to go.
No.
Why you are
Made
earning
an
so
application.
much? Why you want interim maintenance?
Yes, I'm sorry. It is not easy like what the opponent has said. My lords, I made an application seeking interim maintenance of rupees 1,50,000. He suppresses, he doesn't produce any material before the family court, nor family court has insisted to produce any documents.
Yours.
And he represents the husband.
32.
There are two
My lords,
matters. The two matters. Two. First matter
Mm.
by the husband,
Mm.
which I represent. First.
Yes. What are these applicable? What is
My lords,
applicable?
It is the matters between husband and wife, matter was pending in Mumbai. Husband filed an application for transfer of that case. Wife is employed in Canada in a bank. So, in the transfer petition, Honorable Supreme Court called both parties, made efforts, and a very lengthy efforts, and who found that she is also employed. Husband,
Oh, is it the case where the cost for traveling?
exactly same.
Mm.
Actually, my lord said that cannot be indirectly. My lord cannot be interpreted. We have paid that amount. Case is going on in the trial court. I'm informed.
So
that,
you have questioned only that. So
that
your
the-
writ petition has to go.
please, my lord, and that was connected.
What is
when-
their writ petition?
That writ
My
petition
lords,
needs to be paid,
my application claiming
maintenance.
interim maintenance was rejected.
Hmm.
And court has granted me traveling expenses.
That now they are going to pay that.
They have already paid me.
So your petition also has to go.
No.
Why you are
Made an
earning so
application.
much? Why you want interim maintenance?
Yes, I'm sorry. It is not easy like what the opponent has said.
No, I read the order on the last.
Yes,
time.
my lords has read. My lords, I made an application seeking interim maintenance of rupees 1,50,000.
Hmm.
My client is a graduate, MA, this thing, MA, she's a graduate of MA in political science. The husband is a doctor, MBBS, what is his qualification under? MD in community medicine. MD in community medicine. I made an application for maintenance which was declined by the family court. And however, the court has ordered only for traveling expense from Mumbai to Mangalore. Agreed by that order, to that extent order, that is
They have come
grant
before
of
the court.
traveling expense, the husband has preferred a writ petition. I am before this court, agreed by the family court order declining me
Come
to
to the
grant
family
the.
court's order. Why the
Correct.
family court? had,
Yes, my lords.
rejected
Before
it?
take my lords to the finding, I just place two things. Family court declined maintenance on two grounds. I have suppressed the material facts.
Mm.
And second thing is that I have got sufficient income. Court has not dealt with the income of the husband. Just it has gone with the income of the wife. This is
What
how
is the
the
income
family
of the-
court dealt with that.
What is the income of the wife?
Yes, I just place it. And also I take my notes, first of all, my notes straight away, I take my notes to the finding. My lords who find it at page number 43. I take my notes to directly to the finding, how the court has dealt with the
This is
case of the
Second case. Next
Nanna
case.
writ petition, my writ petition. My writ petition, that is
43.
8425, which I have supplied. Ideyala?
842.
Yes.
Yeah. Page 43,
Yes.
yes. My submission as family court has not looked into the entire materials. To put it in short, that is my argument. I'll take my notes to page number 43. Page 42 may be seen, my notes. The affidavit is culled out. Affidavit in terms of Rajini versus Neha has been culled out. 42. It starts from 28, para 28. It means that when she files an affidavit on 21/11/2023 as well as 13/12/2023, she failed to disclose either alienation of any immovable property standing in her name or acquisition of any property in her name. When this court directed her to submit her taxpayer information summary TDS, she is compelled to disclose the acquisition and alienation of immovable property at Mumbai. It is pertinent to note here that her TIS for assessment year 2023 discloses that she sold the security and units of mutual funds of rupees 10,45,424. She purchased two immobile property. Kindly mark this, two immobile properties. This is factually incorrect. For total consideration amount rupees 2 crores 7 lakhs 99 lakhs 741. This is also factually incorrect. And for sum of rupees 1 crore 8 lakhs 82,141. And another property for sum of rupees 99 lakhs 17,600. This is also factually incorrect. The TAS for assessment year 2023-24 shows that she sold the property for sum of rupees 56 lakhs 33,139. All these information gathered from her TAs clearly shows that she purchased the more than 2 crores and sold the property of rupees 56 lakhs 33,130. 2 crores is factually incorrect. Kindly mark this. Next, no doubt that she has produced some family agreement, registered gift deed, etc. But all the same are subsequent to commencement of litigation. Kindly, this is also factually incorrect. Family agreement is before the litigation. A gift deed was subsequent. Therefore, at this stage of the proceedings, that too, while considering the present application, in my opinion, those gift deeds, family settlement deeds cannot be considered. If the said documents were much prior to commencement of litigation, before the marriage of the petitioner, respondent, then the matter would have been different. But the thing remained as it is that respondent during the year 2021-22 purchased the two properties for consideration amount of rupees 2 crore, and for the year 2023 she sold the property for more than 56 lakhs. These materials have been suppressed by the best reason known to her. This is the finding. Next, admittedly their marriage was solemnized on 5/12/2020 at Mangalore. But interestingly, she shown her as a single in her income tax return filed for tax year 2020 and 2021 before the Revenue Agency of Canada. It is relevant to note here that on 30/4/2021, she filed her income tax returns for the tax year 2020. And 29/3/2022, she filed income tax returns for the tax year 2021. But in both the said income tax returns, she shown her marital status as single. Even though at the time of filing said returns, she was married. Of course, this is irrelevant, but however, the court has noted it. But however, while filing income tax return for the tax year 2022 on 5/12/2023, for the first time she has shown her marital status married. But at this stage, apparently on the face of the record, it's clear that she gave false information about the marital status before the Canada Revenue Agency. The said fact is, though not much relevant for deciding the present application, but it shows that she has a habit of suppressing true facts. Pertinent to note here that respondent is claiming 5 lakhs towards the cost of litigation, alleging she spent the huge amount for.
For statement of assessor liability.
Yes, sir. Yes. My lords, we filed 2 statements of accounts and liabilities. My lords, the original records which I have placed along with my memo, output code, which is already on record before.
Take that.
My lords, there are 2 affidavits. That is, one is affidavit filed
Come
on.
to her expenditure.
Sir?
Come to her expenditure.
Yes, my lords would get it at page number. Page 4 of my memo. My lords got it, my lords. In this, I have stated that this is the cost, my lords, 1 crore, 1,40,000.
In that 20,000 has to be deducted because they are paying for your air travel.
Traveling the effective.
Medical expenses, health.
It's only
insurance,
effective.
10,000.
They are paying.
Grocery and laundry charges as per month 15,000.
Yes.
Electricity 10,000. Miscellaneous expenses.
Yes.
2,000. Legal expenses 20,000.
Yes. My lords, I'll just
No,
small
not this-
dates, my lords, for that.
If the expenses are 1,20,000, how much you are earning?
Please, my lords.
Every month, how much you are earning?
I'm not earning anything. I left the job, everything, because I'm staying in Bombay. Now I want to attend the family court at Mangalore. Nobody gives me a job because I should attend the family court. I was in ICSE bank. I got resigned. I left the job. Now the family court holds that I have suppressed the material. I got purchased two property. All are factually incorrect. That is the reason why I placed that documents on record.
Why you are saying that you will not get a job?
Because I should attend it, because my parents are staying in Bombay. I should attend the court proceedings and all, then it's very difficult for me to, because from Bombay to Mangalore, it's very difficult to travel.
You have a flight.
There is
Husband is
always
paying
there, but
Husband is paying the,
because of the shock which,
No.
yes,
it is like something which.
yes, my
cannot
lords
be
is right.
accepted.
Yes, exactly. My lords, now because of the petition filed by the husband, I was shocked and got it resigned. I am not able to work because of the mental
When was the
pressure.
marriage?
Yes, that's the reason why. My lords, marriage takes place on 5th December 2020.
5th December?
2020.
Hmm.
My lords, wife worked in India for a period from April 2020 to 15/1/2021 in child organization Mangalore.
Hmm.
Then wife works in ICICI Bank in Mumbai from April 2021 to July 2022.
What is the salary at that point?
Yes, salary which I have called out in my affidavit. This is the salary. Huh? 25,000, my lords, is the salary. Yes,
When they were separated?
yes, yes. My lords, separation was on 5/7/2021. Divorce petition on 2/7/2021.
27?
21. 27/2021. I'm sorry.
27?
2021. Yes. This is the gist of dates.
So from 2021 till now, she's not working.
Not working. My lords, wife worked in ICICI Bank in Mumbai from April 2021 to July 2022 is the last which I'm.
Then
Yes, my lords. Then my lords will.
where from according to you, the court has inferred all this about the
Yes, yes,
properties?
yes, yes. My lords, straight away, there is a reason why I placed the document on record. My lords, have a look at the documents with regard to the, yes, income tax returns, my lords. Family court refers to income tax returns. My lords would find it at 110 of my memo. Income tax returns of 2021 to 22.
Yes,
My lords got it, my lords.
yes.
This is the tax returns. My lords would get it at serial number 6. Purchase of immovable property 2 crore 7,99,741. Then purchase of securities. These are the details called out. Then I draw my lord's attention to page 111. Last column. Purchase of immovable property to 2 crores and order. Then my lords, page 112. Purchase of immovable property, SFT. This is how the family court, there are two properties. Page 112. My lords got it. I'm sorry.
Yes.
See, first column, that is serial number 1 and 2. This is how the court inferred that there are two properties. That is, one property is 1 crore and odd, and second is 99 lakhs. Then I draw my lord's attention to page 113.
Yes.
This is how the court has inferred at serial number 4 that I have sold the property.
What are those?
Yes, yes. My lords, I draw my lord's attention. There was a family settlement. What had happened was that my father, he was having a property. He sold that particular property and he intent to purchase new property. So for that purpose, he's a senior citizen. He could not get loan at that point of because of COVID period. He could not secure loan. So there was I who have assisted him to purchase the property. I who have assisted from purchasing the property. So in that agreement, I draw my lord's attention to the family agreement. My lords would take my lords to family agreement. That is a part of recording before the family court, page 128. I just read it. This document was placed on record, but this was ignored. This, my lords, have a look at the family agreement dated 13th April 2021, 128, my lords. I'm sorry.
Get it.
My lords, yes, got it.
Yeah.
128. That agreement date kindly be looked into. This is a family agreement dated 13/4/2021. The divorce petition was filed on 27/2021. The family court says that this is a document which was done subsequent to the petition. It's factually incorrect. My lords, I draw my lords into page 128. This is a family agreement which was entered between the father and daughter. Page 129, very next page. My lords, I just permitted to read. First party herein jointly was so and so number, and which is being scheduled to be sold by the end of April 2021, as they have already received the token and booking amount from the buyer. First party is also a sole owner of ancestral land in Guptur, Kaikamba, Mangalore, Karnataka, gifted to him by his parents, and same being sold by him for valid consideration. Whereas the first party attempted to secure loan from various banks for the purchase of new flat. However, considering the age factor of the first party, loan application were not approved. Faced with this institution, first party sought an assistance from their elder daughter, Lalita Devia Kolo, age about 30 years, residing in Canada, for a housing loan. Unfortunately, due to the present court situation, her travel up to India is restricted. She is not a subject. Next minute. Consequently, first party has approached their younger daughter, Delma, hearing the second party. She is a present petitioner who is willing to agree to help the securing housing loan for new home. In consideration of assistance and understanding of second party and her responsibility as a married woman towards her own family, first party is committed to personally repaying all loan installment monthly until its full repayment. Proceeds from the selling present flat of first party and ancestral property will be transferred to the bank account of second party for the payment of purchase amount of new flat in so and so. Another part of the payment will be done either through bank of either parties depending on the convenience considering the current COVID circumstances. It is expressly agreed that second party cannot sell the new property to any third party without consent and signature of the first party, who is actually, it is explicitly agreed that second party cannot sell the new property to any other third party without the consent and signature of first party, who is the actual owner. It's also agreed that money transferred to the second party after selling ancestral property, the first party is presently invested by her in stocks and securities. Same will be withdrawn by her during the time of payment of new property. Any repayment in the future towards new property. Upon full repayment of the first party, second party herein obligates to transfer her share of the property to the first party. So pursuant to this agreement, the property was purchased jointly in the name of father and daughter. That is my claim. My lords, have a look at that is also a part of record. My lords would get it at page number 199. 199. My lords, 199 of moment. 199.
There is no 199 page number.
It is 149, my lords. 149. It's a mistake. I'm sorry. My lords got it.
Yes.
My lords, it is in Hindi because it's from Bombay. Page 143 is a Hindi version. So I got it translated at page 149 at English version. My lords got it. This is the preamble portion of the sale deed. Yes. Now, my lords, have a look at the remuneration column. This is consideration amount. This is 99 lakh 17,600. And actual price is 1 crore 88 lakhs 21,040. My lords would get it at column number 8. This is a sale deed which was purchased jointly by the father and daughter. My lords got it, column number 8. This is how it is transferred. My lords, whatever because of these arrangements, since the father could not secure the loan, my lords, this is the reason why, my lords, the property was purchased. Now, family court holds that it is a two property which is factually incorrect. This is my respectful submission. Court has not looked into these documents. That is my first submission. So far, second submission is concerned, my lords, my lords, have a look at the gift deed also. Pursuant to there, what had happened as per the family arrangement, page 136, my lords. The daughter, that is my client, executes the gift deed. My lords, I'm sorry, page 136.
Yes.
This gift deed is 13/9/2020. That is after filing the petition. That is correct. What the family court finding that gift deed was executed after filing petition of a gift deed.
Why the
Correct.
gift deed is executed in favor
Because the loan which the liability which was taken by the parent, my father, has reimbursed it.
she has reimbursed it.
Yes, the father has reimbursed it. No, what had happened was that loan was taken in my name. The liability to repay was with the
It
father.
is on the father, correct?
Yes, so
Why
it is
is
my
transferred
duty
to
to.
daughter?
Yes. Yes, ma'am.
Why it is transferred to the other daughter then?
Uh,
If you look at the gift deed, it is given to the other daughter.
no. She's a mother.
Mother.
Yes. I'm sorry, I should have enlightened my words. This is how it is transferred.
So earlier in that agreement, when then it appears that she is residing in Canada due to COVID and all is mentioned. It is not mother, I think.
Who?
Come to that sale deed.
Which sale deed? Family agreement. my lords?
Family agreement.
Yes.
Come to that.
Yes.
Page number.
Correct. Yes. Page 129, 1, 2, 3, 4. Fourth paragraph. I'm sorry.
Hmm.
Fourth paragraph which speaks about the first daughter. COVID, Canada. I'm sorry. my lords. Second party in this agreement is my claim. That is this. Yes.
Faced with this situation, first party sought assistance from their
Correct.
daughter.
Correct. Sir, madam. Yes, first daughter, she is not a party. The second daughter is the present petitioner. My lords, any assistance?
No,
Yes.
you are saying that this gift deed is executed in favor of the mother.
Yes.
But from this, it appears that it is not mother, but it is elder sister.
My lords, Lalicia is the mother. My lords, gift deed. Here, this Lavita. Gift deed is Lalicia. Latia. Here, Lavita. Lavita.
Yes.
Yes, ma'am. My lords got it. Yes. Now, my lords,
Which property number gift deed is made? The very same property.
very same, only one property. Only one property. This
Yes.
was an internal arrangement because the age-old father, she could not secure
Yes,
the
yes.
house. This is
Yes,
how
yes.
it was transferred.
So that is
Then
one property.
That is one property. There is no other property. There is no transaction. But in the income tax returns, it gives an impression as if there are
And
two.
what about this 15-16 lakhs, the amount that is lying in our bank account?
Yes. My lords, that is my father. No, my lords, he sold the first property and he purchased this subject property. Whatever the amount which the sale consideration from that first property was transferred. Yes, I'm sorry. My lords, no consideration amount is passed on it. This is a gift deed.
No, that I
50
understand.
I'm
Where from
sorry.
that 15 lakhs?
56 lakhs is my lords is pointing out.
1.5.
15. Where it is? Yes, in the bank account transfer. My lords is pointing out the bank account transfer. Yes, my lords. My lords, have a look at I have given explanation also in the notes of argument, how it is. I'll place that statement of account extracts. What are things which had happened? Kindly see page 154. That's,
Yes.
page 153 is the notes of arguments which are submitted by the wife before the family court. Page 154 is my explanation. Because my statement of account shows of different transactions which has impressed upon the family court to draw. Page 154. Kindly see para 3. Narration the statement produced by the respondent
Yes.
shows that in the year 2022, she had a salary of rupees 9,45,365. That is for 1 year. Bank of rupees 5,43,172. CHT group rupees 40,21,093. This statement also reflects loan of rupees 15,77,553.
No, if her salary is 25,000 per month,
Correct.
where is this 9,45,000? And according to you, she worked for 2 months.
But it's 2 years, 2020 in the 22 one.
For 2 years.
Yes, yes.
Hmm.
2 years. Then, no doubt, learned counsel for the petitioner submits that sum of rupees
Her
50.
income should be per year, how much?
Please, my lords.
It would be 3 lakhs.
Yes, yes.
What is this 9,45,365
Uh,
at para number 3?
correct. CH group.
Hmm?
Husband, no, my lords, what had happened was that the husband has called me to join with his group. He was running with the CH group, CHT group
No, narration is
organization.
a statement by the respondent
Correct.
shows that in
Correct.
the year 2020 to 2022, she had salary income
Correct.
of 9,45,365.
Correct. Which includes, yes. Yes. Yes, my lords, in that, the out of salary income of rupees 9,45,365, 5,43,172 is from the salary which is gained from the bank.
How she will get that much salary?
That's what this thing indicates, statement of accounts. Hello? Huh? Niente. Yes. One year, 4 lakhs. Are you sure? My lords, as per the instruction, it is submitted for 1 year, 4 lakhs is the salary.
It should be 3 lakhs if it is 25,000.
25, correct. 4 lakhs or 3 to 4 lakhs. Can you produce salaries? Yeah. Produce salaries slip. I can produce salaries slip also, there's no issues.
Yes.
So what I want to try to impress upon the court is that, my lords, the family court has not dealt with these things. It has just looked into.
So, and understand that one property,
Yes, yes.
the court had referred to 2 properties.
2 properties.
That is
That's
not
one
two
thing.
properties,
That
it
is
is
one.
one property.
Yes,
And the property is purchased by the foreign.
correct, correct.
She has only because she only facilitated to obtain the loan.
Yes, yes.
Hmm.
Then my affidavit was this thing, what
And her
settlement
income per
also has
month
been
her
ignored.
income per month is 25,000.
Correct. My statement that one settlement deed which was executed, that was family arrangement deed which was
Yes, yes,
produced,
yes.
that was also ignored by the family court. So if family court would have been looked these documents, probably the result would have been different.
Yes, Mr. Senior Constable asked. Yes.
Third, the case is now one aspect of the matter. After the honorable court's observation other day, the deposited she has come for cross-examination, but the cross-examination has about 15 to 20 times cross-examination has happened. Now it has gone for, again they sought cross-examination, we are cross-examining. They are taking time. And there is in fact a direction by the Supreme Court for a speedy disposal. Now it's, we have deposited the amount, she has come for some dates, several dates she was absent again. And because of the absence, case could not go. And after some cross-examination, again, they seek time, matter is going on. One submission at the very outset is, all these documents which are now produced, their subsequent matter was before the Honorable Supreme Court. There is also one order of the Honorable Supreme Court, page 52, my lords, in my petition.
Regarding the maintenance, the question was left open. That is been culled out here.
Read it and say how
Yes.
it is kept open. Page 52, your lords may kindly see.
It is culled out in the judgment also.
How it has happened. How
Page
the
35.
time has been spent, my lords.
Page 35.
My petition, page 52, my lords, in my petition, please. Page 52, first para is about the transfer, then the marriage, everything has happened in Mangalore. Parties are actually from Mangalore, my lords, originally from Mangalore. Then, my lord, your lords may kindly see page 56.
Yes.
Page 56.
Yes.
Para 8. In fact, petitioner being a permanent resident of Canada was habituated of that lifestyle. Marriage was just to spoil the life of the respondent. Initially, it was claimed that she was love singer. It is alleged that the respondent had shunted out the petition from matrimonial home. However, it was her own decision to move out. Immediately after reaching to Mumbai, she applied for job ICICI Bank, a resignation from organization on 9/2/2021, where she was working with the respondent. She had joined the job on so and so. Number of efforts were made by the respondent to reconcile. Para 9. Respondent was also kept in dark about the location of the new flat worth ₹2 crores purchased by her and her family. The respondent came to know about the address when she filed a complaint at so and so, my lord. Now, after this, now I beg to take the honorable court about these contentions about the claim, my lords. Now beg to take the honorable court to page 59. Now I beg to pause it for a moment. These documents, there is an agreement between the father, they are released, etc. Everything comes later. Nothing was there. According to our case, my lord, this alleged family agreement
No,
is...
no, but before the Supreme Court, why it should be?
No. Thereafter, my lord, this matter went on for a long time. It was before the honorable, that question, my lords. There was the honorable Supreme Court spent a lot of time and even appointed one of the honorable High Court judges, my lord. Went on several months, I am informed, my lords. And that also I bring to the kind notes of the honorable court. That, my lord, this document, my lords, that alleged family agreement, is a setup document that is now produced later in the family court, which is disputed by us, my lords. This setup clean and the stamp paper. We don't want to reveal everything, my lords, on the face of it. Stamp paper when it's there, the date when it is there, because all these are now the questions before the...
It's a registered document.
The family document is not registered. In the stamp paper, they have prepared it, my lords. Subsequently, on the old stamp, they prepared it, my lords. That document on the face of it, your lords may kindly see, which is
This
now...
will take that it's not a registered document.
No, not a registered document. The face of it appears...
So for what purpose you want to rely on the Supreme Court judgment?
Supreme Court is this, my lords. About this claim, your lords may kindly see page 59.
Yes.
Para 17. From the order dated 13/10/2022, it is evident that the petitioner may be working in Canada. She stated that she wound up her work in Canada and she is now living in India. They agreed to take assistance to the marriage council. Justice S.J. Wazifdar, former Justice of Punjab and Haryana Court, was appointed as a mediator. The report has been received from the mediator stating that despite spending about 50 hours in different sessions, the parties and family members could not arrive at a family settlement failed as per so and so. Specifically, according to the mediator in the report, that during 4 months, several meetings were held with the parties, though the petitioner was in Canada. And she attended the meetings through video conference. Para 18. Then, my lords, I will not read para 18 because it's about this one, my lords. Then para 19. Petitioner is a permanent resident of Canada. She had shifted there in the year 2014, was working there on a well-paid job. Came to India for the matrimonial alliance. She is presently based at Mumbai, Maharashtra with her parents. stated to be working in ICICI Bank. No child at the marriage. Relation started after the parties met on Facebook. As far as the respondent is concerned, he is a doctor by profession. He is living in Mangalore. Divorce petition has been filed. So and so, husband at Mangalore, where he resides with his aged parents. Then, my lord, para 20. Middle portion, my lords, mediation report dated 8/2/23 submitted by Justice H.A. Vasibdar. Petitioner was in Canada throughout the mediation process, attended the mediation there. There is one child born out of the marriage. Both the parties are well educated, engaged in their own jobs and professions. They can travel to Mangalore to attend the hearing of the sponsor, can also seek exemption. Though at present condition, the finance condition of the parties, the finance condition of the company. We do not find any ground issuing direction to the respondent to pay the expense of petition in traveling, my lords. Then still she feels like then seeking reimbursement of expenses, my lords. She will be at liberty to file application before the court concerned. Based on that, she filed an application for the expenses, my lords. Now, my lord, even this prayer, etc., was made, my lords. There also.
They have lived together for 40 days.
That's all, man. That's all, man. That's all. And then, my lords, after the matter was transferred to Lordship may kindly say, all steps are taken, my lord, to defeat the process of the court, to delay the proceedings. Even though the transfer order, your Lordship may kindly 18/4/2023, my lords, continuously being delayed, despite the specific order is there for this one court to expedite the process, my lords. And kindly see, as far as the orders that have been passed by the family court in the present case, my lord, which is now impugned before this honorable court. That order, the lords may kindly see, 7th February 2024, order was passed. Thereafterwards, my lords, of course, the honorable court in that case, my lords, provided for 8,000. And then, my lords, 8,000, we had our objection because she's never coming. She's continuously dragging on the proceedings, my lords. Then we came up before this honorable court. So since then, it's only because my lord directed that this petition also be tagged with this. Now it is tagged. Now, my lord, the trial judge considers everything as far as they raise up a defense now, my lords. This is not my income, I have resigned, etc. And that the amount of crores has not come from me, father has contributed, etc. These are all, my lord, the defenses which have been subsequently set up, my lords. It's not at all, there's absolutely no truth in all these defenses. Now, my respectful submission is, my lord, that the trial court, I will regard all the materials, comes to this conclusion, my lord. It cannot be said that it is illegal or perverse, my lords. Now, all arguments are advanced making a defense, my lords. The defense is required to be tried. Now, cross-examination is going on. If she cooperates, appears at least 1 or 2 days, one may make one submission, my lords. Okay. For a family court, cross-examination, my lords, of either this or the other party, my lords, I respectfully submit it should be for, my lord, 3 hours, 4 hours, or 5 hours at the most total, my lords. Maybe stretching to 1 or 2 days. This, my lords, this is going on. An unfortunate incident, my lords, going on for 2-3 hours every day and for 10 to 15 hearings. Even now they say they are going to cross-examine. Unless this honorable court directs, my lords, that it should be held and she should be present on every day, she will not be present also. She say, I'm Mumbai, I'm not present. Husband would come, advocate would come and again go. And then said for further cross-examination, time is required. It would not be done. It will never be done, despite the honorable courts directed, my lords, because the honorable court will only direct for expeditious disposal because number of other cases are pending. Now the honorable family court is taking up the matter. I'm informed yesterday it was there. Again, she did not come. And this is a short time. And so they do cross-examination, my lord, for little time, my lords. Then they say one time and go on. And my lord, unless this is controlled, this will never end, my lords. Now, the case itself can be over by a month or so if she cooperates with the proceedings. So, my lord, the order of the learned family judge, including both orders, my lords, I humbly beg to submit, my lord, that is already finding given that how she has suppressed and now she has actually concocted false records. We may have to initiate action also for creating a family record on and dating it after 4 months of the illegal stamp paper. January stamp paper, they make it as 4 April. And this is all to defeat the court order, suppress her. And my lord, she was assistant manager, admitted, and worked in Canada for several years. And assistant manager residing along with the parents. Now they say we resigned. And we are at the job. And that is very hard to believe because all the records of income tax She has other income, my lords. Everything is borne out from the income tax records. Now, my lord, since it's the fag end, my lords, my humble prayer before the honorable court is kindly direct her also to cooperate and finish the case at the earliest, my lords. And the impugned orders, my lords, does not require any interference, my lord.
Yes. Please.
My lords, fact is, unregistered document is factually incorrect. It's a registered document.
Yavudu? Family arrangement.
128, it's a registered document.
Where is that?
Afterwards,
Yes, 120. Then, my lords, 128 of my memos.
128. Notary, sir. Before the notary, sir.
Family agreement.
Yes. Register number 06,
That's stamp paper, sir.
register number. Kindly see. Registered number also is indicate page 130.
No.
It's a registered document.
Huh?
That is one thing.
128
Second thing,
stamp
my
paper,
lords.
Sir. Sir, kindly see now itself, my lords. Right side, stamp paper is of January. And oath commissioner, so and so on 13/4/2021. Notary.
Let
Stamp
family court
January,
decide all
I don't
these
want to
things.
say
Let the
anything.
documents be looked into. Let the
22
family.
January 2021, sir.
What is it?
And stamp paper. And eligible agreement is 13/4/2021. They got a old stamp paper and gets it before the notary and they want to produce this. I don't make any comment on the face of it.
My lords, I have produced, they have not objected for it. Now it's of the first time across the bar is making a submission, one thing. Second thing is that my lords, all the not cooperating, all those things is not a matter of record. They have not produced any document to show that I am not cooperating as such. Third thing is that my lords, before marriage, I was staying in Canada. I am not disputing it. And after marriage, he has called me that you should leave the job and come back to India.
Is it a case that you, both of them lived for 40 days?
Please, my
Yes,
lords.
only for
Please, my lords.
40 days.
40 days?
They live together.
That's all. Nothing more. I am drawn to, my lord, that is the date which I have pointed out. That's correct date according to my submissions. And other things is that my lord's court has not dealt with the income of the husband at all. Has just put on the burden on the wife. I am not misting on the part of the family court that no burden should not be imposed on the wife. I made best efforts to produce all those. Family court has not looked into all the documents. Let the family court redo the whole thing. It is not the case that madam not cooperating. I'm coming down from the Mumbai, I'm cooperating with the family court matter. It's all factually incorrect.
When is this application filed?
Yes, this application is filed on.
Maintenance.
Yes. And my notes, application was filed on, just I'll assist my notes. This application was filed on. Tell you that. Page number 191. I'm sorry, should I assisted my notes? 7/10/2023.
710?
2023. I'm told that my lords, he have got 2 flats in Mangalore. 1 flat in Mangalore, 3 BHK house, and he has got property in Mumbai also. Let him pay at least little sum of money. At least
What is the income of the husband?
the court has never dealt with the income of the husband at all. He suppresses, he doesn't produce any material before the family court, nor family court has insisted to produce any documents. Let court, this family court, let they decide, my lords. If my lords have a look at the impugned order, court never has dealt with the income of the husband, nor it has only imposed burden on the wife. Just see the impugned order of the family.
No, my lords, these repeated submissions is, my lord, that he has been cooperating and appearing. My lord.
Here on the
And my lords,
maintenance
expenditure is granted.
have to have-
Aspect also, my lords.
For effective hearing, only the expenditure is granted by the family.
Please.
If there is an effective hearing, then expenditure has to be borne by the husband. Kindly see the impugned order. If it is only effective hearing.
Effective hearings when she appears.
Effective hearing means you appear and do
No, if-
some,
No, my lord.
some business
what
is
family
conducted
court
in the
say.
court. Otherwise, no.
No, I'm sorry. That's what the family court reads.
Yes, heard reserved. Next.
Grateful.